Hello everyone and welcome to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are discussing about the important aspects of legal reasoning, which it is an important portion of your CLAT examination in which there are questions which are put up to the CLAT aspirants in regards to how the legislations and the laws that is governing the Indian society, how they can be made applicable in the real world scenarios, where which you will be given a set of paragraphs, and in that there will be embedded the laws or the rules, and then you have to figure out at which particular legislation we are referring to. And for that we have started with this particular lecture series, where which we have so far discussed numerous legislations which are going to be helpful for you in your preparation for your CLAT examinations. So far, we have discussed about the law of contracts along with the criminal laws. We have also discussed the constitution law, and we have also discussed about the law of torts. After that, after completion of all these important legislations, which are perhaps an important aspect of your legal reasoning portion, the questions will obviously be asked in other sectors also, but the legal reasoning portion is where you will find mentions of the laws and the legislations as such. Remaining of the portions of the CLAT examination focuses over English, quantitative aptitude, logical reasoning, and your comprehension. So what exactly we need to understand here is that the legislations that has to be understood, which are going to be helpful for you when you will be attempting the CLAT examination. Those legislations, you are not supposed to study the whole legislations as such, but only the parts and bits of the important portions of that particular legislation. For example, if we talk about the Indian Contract Act, when we studied in our previous lectures, we understood that what exactly is the capacity of the contract and how the contract can be made, and who are all eligible for a contract, how the communication of the contract is completed, what is contingent contract. So all these informations will be helpful for you when you will be attempting the paper. What exactly is the difference between voidable and valid agreements? So these things will come up handy whenever you are going to attempt the papers. Once you know the principles, once you know the laws, it becomes perhaps easier to figure out what exactly is right and what exactly is wrong. And since it is a multiple choice question paper, MCQ paper, so you will have to figure out from the 4 options that will be provided to you. So once you have that confidence, after you have studied the principle, after you have practiced a lot, and after you have analyzed that how the principles are going to be applicable in your questions, then it perhaps will be a very easy task, or if I rather speak, it will be a cakewalk for the CLAT aspirants to figure out what exactly they need to mention and what exactly should be the answer. In our previous lecture series, we started with the Hindu Marriage Act, as well as we have studied about the sources of both the Hindus as well as the Muslim law. Because when we talk about CLAT examination, it also have the families law as one of the subjects in regards to your legal reasoning portion. So we are trying to figure out that what exactly are the important areas which one has to be very much clear, and has to understand those concepts, because after understanding these concepts, it will perhaps be a very easier task for the CLAT aspirants to figure out the principles and then apply it. So in our previous lecture series, we were talking about the conditions of Hindu marriage. So far, we have started with the Hindu Marriage Act. We have completed the sources of Hindu marriage, and what are the sources of Hindu laws, and what are the sources of the Muslim laws also. We are focused over the Hindus and the Muslim laws only specifically. The reason being, these laws are considered to be the major laws or the major legislations, and the questions that will be put up in front of you will be comprising from these major laws only. So we will try to figure out that what exactly are those laws which will be helpful for us in our examination, and accordingly we have explained to you in the previous lecture series that what exactly are the sources of law, what exactly is custom, what exactly is shruti, smriti. And when you come to Muslim laws, we have studied about what exactly is Quran, how the Quran came into play, who is Allah, how is Muhammad considered to be the follower of Allah, and what exactly is the sources of Muslim laws. So we have studied that there are perhaps various sources when you talk about Muslim laws also. And then we have talked about the two set of communities that were formed, one being the Shias community and one being the Sunni community. And then we discussed the different schools of thoughts in regards to both the Hindu laws as well as the Muslim law. And now, after completion of those sources, we directly proceeded further with the legislations, which has been codified in regards to Hindu laws. For Muslim law, it is still not codified, so we still follows the old customs and whatever the waqf boards and the other spiritual leaders of the community provides information that these particular will be the laws and the rules. So we will be focusing over that things also. But when you talk about codified laws, it becomes a perhaps easier task to understand it, because it is a law. It is a law and a legislation that has been enumerated for the betterment of the society. So, in the same way, when you talk about the modern sources of Hindu law, so the laws were codified. Earlier, it was not codified. There were different commentaries and digests which used to provide, under different judgments which used to provide us that what exactly has to be done in particular scenario. But after a certain period of time, with the development of the society, it was perhaps needed that we have a codified laws, and then we created these particular legislations like the Hindu Marriage Act, the Hindu Succession Act, the Hindu Maintenance and Adoption Act, then the Muslim Dissolution Act. So all these acts are the part or the areas which governs the laws in regards to Hindu marriages, and more specifically in regards to Hindus. And so in those particularly, what we are when we talk about these legislations, we are talking about legislations which is going to govern Hindus at large. And then we have studied what exactly will constitute Hindus according to the Hindu Marriage Act and the other different legislations. Perhaps the definition of the Hindus is same in regards to all the legislations that we are going to study. They are talking about that the Hindus shall include Buddhist, Jain, Buddhist, Jain, and Sikhs, and it does not include, and it shall not include Christians, Parsi, Jews, and Muslims. So perhaps basically what we try to understood here is that what exactly will be the scope of this particular legislation has been enumerated when they were explaining what exactly is Hindus. So it is specifically and strictly applicable to Hindus, and that particular things we have already studied. In our last lecture series, we studied about what exactly shall be the conditions of Hindu marriage. So let's quickly revise what exactly is the conditions of Hindu marriage, so that we can move forward and we can see what are the important other legislations that needs to be taken care of when we talk about the Hindu marriage as such. So, under Section 5 of the Section 5 of the Hindu Marriage Act of 1955, we have studied about the conditions of Hindu marriage. So, remembering the section is as such is not that much important, but if you are remembering, it is something which is known as extra marks for good in writing, if I would say. But when you talk about the concept, it is perhaps important for you to understand what exactly this concept is saying. So when you talk about the concept, when we talk about the conditions, that how the Hindu marriage will be considered to be a valid Hindu marriage, we need to see that these particular conditions are fulfilled. The first thing is that neither party or spouse has been present at the time of the marriage, okay, and whether they were capable of giving the consent or not. Though capable of giving the valid consent of such mental disorder of such kind, or to such extent as is unfit for marriage or the procreation of child, has been subject to recurring attacks of insanity. All these things we have discussed. Then what exactly will be the age? Then what exactly will be the age for the groom and the bride. Then the parties has not been stopped by the prohibited degree of relationship. We studied about the sapindas. So those, if the particular persons are falling within the scope of a sapinda relationship, then that particular legislation is not being considered to, that particular relation is considered to be a prohibited relationship, and then that particular relation, the marriage cannot consummate. So we have to make sure that all these conditions are being fulfilled. And if you are not clear that what exactly is sapinda, you can refer to the previous videos which we have explained in detail that what exactly is sapindas, and it will be helpful for you to understand that how this particular sapinda relation, which is under the degrees of prohibited relationship, stops a person or prohibits a person from marrying in that particular relationships. So that is something that you need to keep in mind, because it perhaps is very important, and this is not, the parties are not sapindas in each other unless the customs or the usage governing each of them permits the marriage between the two. So we have understood it, that what exactly are the important areas which are going to be there in regards to your conditions for the Hindu marriage. Okay, these 5 conditions has been enumerated under section 5 of the Hindu Marriage Act. Then when we talk about, this is your Hindu Marriage Act, then this registration, and we have already talked, ceremonies we have already talked. I'm so sorry, I'm not able to, there was a little bit of congestion in my chest, but anyways, let's continue. Restitution of conjugal rights, this is also important for you to understand, and we have already explained it to you in our previous lecture series. You can just go through it you can, in order to understand that what exactly is the things that we have informed. Whether either the husband or the wife has without reasonable excuse. Okay, so what happens in restitution of conjugal rights are that whenever the person gets married, okay, so whenever the person gets married, he or she gets some rights, and those rights are called conjugal rights. So once those rights after the marriage you have received, you have now these conjugal rights, and if those rights are not being provided because of desertion, because of withdrawing from the society of your husband or the wife, then the aggrieved party, the person who has not deserted or who has not withdrawn from the society, for example, there is one person X, another person Y. They get married. After a certain point of time, X withdraws from the society. When we say withdraws from the society, what does that mean? What does that mean? It means that the person is not abiding by the obligations of his marriage. So what happens is that the person who was supposed after the marriage, they are supposed to maintain the wife, they are supposed to take care of their children, they are supposed to make sure that the family is in a very peaceful atmosphere. All these information, all these things becomes very important when we are discussing the restitution of conjugal rights, that the withdrawal from the society, it doesn't mean that the person will not be available in the society. Okay, it doesn't mean that the person shall not be seen or visible in the society, or he has gone to some another district or another country or something like that. Meaning which, when you say about the withdrawn from the society, we specifically mean that the person who has married, it has failed to abide by the obligations of that particular marriage, and the rights of the person who has not withdrawn from the society and who wishes to continue with that particular marriage has been suffering. So we can file a petition to the district court claiming that I have been married and the other person, but the person with whom I have been married, is not providing me with the conjugal rights that I deserve. So kindly help me get my rights restored, so that that particular petition can be filed in the district court for the restitution of conjugal rights. And the court, on being satisfied of the truth that the statement made in such petition, and there is no legal ground why the application should not be granted, may degree restitution of conjugal rights accordingly. Okay, so they will say, okay, you are not supposed, you are whatsoever you are saying that you are not able to abide by the obligations, it is something which is not true. The court will direct the other person, the person who has withdrawn from the society, that you are supposed to assist your spouse. Spouse means either the husband or the wife in the day-to-day things, and you are supposed to abide by the obligations of the marriage. I'm so sorry. Abide by the obligations of the marriage, and if you are not abiding by the same, then it is considered to be a wrong, and the person can go to the district court and get their rights restored. So this was about the section 9 of the conjugal rights. The only thing that you need to remember here is that what exactly is conjugal rights. So conjugal rights are those rights which is given to a person on the pretext of him or her getting married. Okay. Now we'll talk about judicial separation also, because there are two things. One is divorce, and other thing is judicial separation. Okay. So what exactly is the difference between judicial separation and divorce? We'll try to understand it. Either party to a marriage, whether solemnized before or after the commencement of this act, okay, may present a petition praying for a degree of judicial separation or any ground specified in subsection 1 of section 13, and in case of a wife, also any ground specified in subsection 2 thereof, and which the petition for divorce may have been presented. So what happens is that whenever a person wants to get divorce, okay, they tried their level best to make sure that the marriage is subsisting, but because of reasons unknown, because of various other problems, both the parties feel like that their marriage is not going to continue. So what they need to do is they need to file an application for judicial separation. It is not like that you will directly get a divorce. First, the court will see. And why is it so? Why is it so that you will not get directly divorce? Because when we talk about the marriages under the Hindu law, marriages under the Hindu law, those marriages are not considered to be a contract, but rather a sacrament. And when we say a sacrament, we mean that the judiciary will try to make sure that to the maximum possible limit, that without breaking the marriage, if the marriage can subsist and the marriage can continue, then they will try their level best to get that particular thing into motion rather than providing divorce. Because since it is considered as a sacrament, then obviously it is their obligation to buy of the judiciary that they are not proactively providing divorce. Because if that would have been the scenario, then what will happen is that everybody, if there will be a small and petty dispute, and disputes in Indian society, when you talk about families, is perhaps very common. There are times when you are not confident and you're not clear over a particular aspect, and that particular aspect causes a lot of difference between the spouses, and then eventually they decide that yes, we have to go for divorce because this particular marriage will not be able to subsist. But those matters are not very much severe. They are trivial matters, and for that, in order to make sure that yes, the persons, the husband and the wife are trying to negotiate and try to reconcile about their marriage, immediately giving divorce according to the Hindu Marriage Act is not provisioned. First, you need to provide judicial separation, and then you will have to see for a period of 6 months that whether the both the husband and the wife are not cohabiting, they are not meeting. And once when the court has this particular thing in their opinion that yes, this particular marriage will not be able to continue forward, then only they provide divorce. So we need to see that what exactly are the grounds that we'll be obviously studying when we study about the divorce. But you need to understand that judicial separation is not actually divorce, but it is a degree or an order. It is an order passed by the court saying that you people are not supposed to meet, but rather you will be separating, you will be living separately. And then you see to it that what exactly is your whether you are able to continue, whether you still want that the particular marriage should continue. Then after that particular 6 months of time period only, the court will provide divorce. Where a degree of judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit. Okay, so it is not obligatory; they can live separately with the respondent, but the court may, on application by the petition of either party, and on being satisfied of the truth of the statement made in such petition, rescind the degree of it, considers it just and reasonable to do so. So if you feel like that there is a case of, for example, there is a case of divorce. Okay, there is a case of judicial separation that has been filed in the court. Now the thing is, if it is not obligatory, okay, it shall not be obligatory for the petitioners to cohabit. Okay, for the petitioners to cohabit with the respondent. But if the court feels like, what happens is that sometimes people are of different opinions, and they if there is a petty dispute also, they wish to separate their ways. But once you try to cohabit together, once you try to understand what exactly is the other person's statement, what exactly is the other person's reasons for that same, then you will be able to understand that okay, this needs to be done, and this is something that should not have been done. So the court has this authority also that they can pass an order where which you have to be living separately, and then only if the court feels like that you are not coming back by yourself, then only they will be providing the degree of divorce. Okay, so the judicial separation, perhaps it is important for you, but not that much important when you get compared it from the 4 portions that it's very important in regards to your marriages, in regards to your CLAT examination specifically. First is the condition. Condition is something that you should be clearly understanding. Then what exactly is void, voidable, and valid marriage? This we have already explained. And the third one is what is divorce and what are the conditions of divorce, divorce conditions. Ceremonies we have already studied. So that is something that we need not go forward with. So condition we have done. Void and voidable divorce marriage is something that we're going to discuss right now. Ceremonies we have done. Then we'll discuss about the divorce and their conditions. Okay. So when we talk about void marriages or voidable marriages, or when you talk about valid marriage is the conditions that we have already studied in our section 5. Now, when you talk about void marriages, what you need to understand here is that whenever any marriage solemnized after the commencement of the act, okay, so this is something which is applicable proactively. After the commencement of this act shall be null and void and may on the petition presented by either party thereto. Okay, so on the petition presented by either party thereto against the other party be so declared by a degree of nullity if it contravenes any one of the conditions specified in clause number 1, 4, 5 of section 5. Okay, now let's see what exactly section 1, subclauses 1, 4 and 5 of section 5. Okay, we have already studied it, but let's try to understand it here. Okay, so first condition is saying this is void. If any of the parties or the spouse has has if both the parties X and Y has any of the spouse present, okay, meaning which they are already married, then they cannot remarry. If they do so, then that particular things will be considered as a void thing and it will be a void marriage. Okay. Then what is the next condition that was mentioned there? Let's try to figure it out. That was number 4. So let's see what exactly number 4 is saying. Number 4 says that the parties are not within the prohibited degrees of relationship. Means sister brother, mother, son. So if you can see, when we studied the definitions, okay, when we were studying the definitions, okay, we've studied the customs, we have studied the district code, we have studied uterine blood, prescribed, we have studied the subpenda relationship that has been mentioned number F1. Okay, 5 linear ascents for the father, 5 linear ascents for the father, and 3 linear ascents for the mother. Okay, and that is considered to be a subpenda. Okay, and then prohibited relationship. What is prohibited relationship? If it is 1 linear ascent, so all these are considered to be prohibited relationship. Okay, these are prohibited relationship. And if anyone falls within this particular scope, that is under clause 4 that has been mentioned. And also clause 5. What is clause 5? This is the parties are not subpenda of each other. So let's try to understand here on the void marriage one. The first is that they should not be already married. They should not be already married. Second is prohibited relationship. And the third one is subpendas of each other. Unless there is an exception to that particular thing, unless custom allows. Unless custom allows. So if any of these 3 things are present, then that marriage will be considered as a void marriage, meaning which that particular marriage never existed at the very first instance. But here you need to understand one thing, and there is a very small thing, and perhaps it is not important for you in regards to your CLAT examination, but for a general perspective it is perhaps very important. If you read it minutely, then it has been mentioned here that any marriage solemnized after the commencement of this act shall be null and void. Okay, so shall be null and void and may on the petition presented by either party thereto against the other party be so declared by a degree of nullity if it contravenes any of the conditions of if it contravenes any one of the conditions specified it in clause 1, 4 and 5 of section 5. So it is by default it is void ab initio, that even if these 3 things are present, if there are these 3 things are present, then the marriage by default is void ab initio, that the marriage never existed in the very first place. But in order to get the degree, in order to get a declaration and an order from the court that yes, my marriage was not solemnized and this marriage is not a valid marriage, the petition has to be presented by either of the parties. Either the person who has been suffering will be presenting in the court, and then they will be getting a degree of divorce. Unless that particular degree has not been granted, then it is something which has been assumed. So it is the duty of the court to figure out whether the particular things are true or not, and once they have given the degree, the marriage will be considered as null and void. When you talk about voidable marriage, voidable. So if you talk about voidable, what does it mean? Voidable, you divide it into 2 portions. Voidable, a marriage which has the ability to be converted into a void marriage, then that particular marriage is called as voidable marriage. Now, what are the conditions? Any marriage solemnized whether before or after the commencement of this act, shall be voidable and may be annulled by a degree of nullity on any of the following grounds. What are those grounds? That the marriage has not been consummated owing to the importance of the respondent. Okay, so if either of the parties are important, that is, they are not able to have sexual intercourse with the spouse, then that particular marriage will be considered to be a voidable marriage at the instance of the party who has been suffering. For example, there are two persons, X and Y. X is important. Okay. Now, it is over the Y until unless Y does not file a petition claiming that this particular marriage cannot be subsisted because owing to the importance of this particular respondent, then only their marriage will be converted into a void marriage. Okay. In the earlier pretext, even if that particular petition has not been filed yet, still the marriage is still an invalid marriage or a void marriage. It is still a void marriage, even if the petition has not been filed, because it is contravening by section 1, 4 and 5. So this is the difference between void and voidable marriage. In void marriage, even if the degree of nullity has not been declared, nullity has not been declared yet, then also if it is contravening section 1, 4 and 5 of clauses 1, 4 and 5 of section 5, then the marriage will be considered as a void marriage only. But when you talk about voidable marriages, it is important to understand here that when you talk about voidable marriages, these marriages are very much valid. You cannot say that this particular marriage between X and Y, because of the impotency of X, is a void marriage at a very beginning stage. No. It is a perfectly valid marriage, but if either of the parties who have been aggrieved, either X who has if Y, in this particular instance, if Y feels that because of the impotency of X, this marriage cannot continue, then she will file a divorce petition. Okay, or she will say to the court that this particular marriage is voidable at the instance because my husband is important and because of which my marriage has not been consummated or I was not able to have sexual intercourse, that marriage is in contravention to the conditions specified in clause 2 of section 5. The person is mentally ill or incapable of giving the judgment. So it is not like that the person, mentally disturbed person he cannot get married. No, it's not like that. You need to understand. A mentally incapable person can also get married, but it has to be proved that the person with whom he is getting married has the knowledge that the person is mentally incapable of giving their judgment. And if they marry, both the people will be considered to be in a valid marriage. But after a certain period of time, when X comes to the knowledge that I have been married with Y, when I was not able to provide my consent, then at the instance of X, he being mentally incapable of providing his consent, it will be voidable because he was not able to provide the consent, but rather Y, knowing to this fact or owing to this fact that X is mentally incapable of giving or rendering a judgment, and knowing the fact that X is mentally incapable, still agreed to get married to X, then the marriage is perfectly valid for Y because his consent or her consent was valid. But after later stage, if it comes to the knowledge of Y that while she was marrying X was it was portrayed that X is a sane person, but after later stage it was revealed that X is not insane but is rather incapable of rendering judgments and because of insanity, that Y also will have the authority or the right to get the marriage dissolved, because it has been there has been misrepresentation, or the consent of Y was not given freely. So that is how under clause 2, which talks about insanity and everything, under section 5 of clause 2, that particular marriage will be considered to be a voidable marriage. So when you talk about voidable marriages, the conditions first is impotency. First point. Second point is insanity. What is the third point? Let's see. That the consent of the petitioner, where the consent of the guardian in the marriage of so this is something by fraud as to the nature of the ceremony or any material facts, then this particular marriage can also be considered. And the fourth point is that the respondent was at the time of the marriage pregnant by some other person than the petitioner. Okay, so the third point is third points let's not take into consideration because that is not important for you, but fourth point is important, and that is pregnancy. So if any of these three grounds or four grounds are present, then that particular marriage is still, until unless any petition has not been filed in regards to nullity of that marriage will be considered to be a perfectly valid marriage. But once this petition has been provided, then that particular marriage will be considered to as important if these conditions are present, being impotency, insanity, or presence of pregnancy by some other person. Then that marriage can be considered converted to a void marriage if any of the parties or any of the spouse feels like that they cannot continue with this particular marriage, they can file the petition, and then after the pronouncement of the decree, then only the marriage gets converted from a valid marriage to a void marriage. Understood? So when you talk about the major difference between void and voidable marriage, void marriage is void ab initio. Void ab initio means it is void from the very beginning. Even if the person gets married, then the conjugal rights that are supposed to be provided to the spouses shall not be given, because that marriage never existed at the very first place in the eyes of the law. And when you talk about voidable marriage, that marriage is a perfectly valid marriage, but because of these conditions that are present, the spouse feels that they cannot cohabit and they cannot move forward with this particular marriage. They can file degree for nullity, and then if the court is satisfied, then they can they can convert that marriage from valid marriage to void marriage. That is what is known as voidable marriages. I suppose the concept is clear to you. What exactly is the difference between that? Okay. Notwithstanding anything contained in subsection, no petition for annulling of marriage on the ground specified in clause C of subsection 1. Now, what is clause? This is clause C. So this is becoming not important for you. So let's skip this part. This is an important portion for you to remember when you talk about clause D, which is talking about the respondent that they were pregnant. If the other person is ignorant, okay, if the petitioner was at the time of the marriage ignorant of the facts alleged. Ignorant means that he somehow had doubt, but he still proceeded further and married that particular person. And after the particular marriage, the petitioner files a case that I was not aware of the fact that she has been pregnant with some other person. Then the marriage shall still be considered to be a valid marriage and cannot be converted into a void marriage, only because the petitioner was ignorant of the facts. that the person is pregnant. So that is something that you need to remember. The first point is this. So these are some important points. I would request you to just go through it. If although it's not important, but when you talk about exceptions sometimes play a major role, because this particular information that the petitioner was at the time of the marriage ignorant, how will it be coming in your question paper would be that there is one person X who was supposed to get married to Y. Y was pregnant at the time of the marriage from some another person Z. X already knew of the fact that there was some relation between Y and Z, but he ignored and proceeded further and married Y. Now, after 6 months time period, after 6 months, it was observed that X had filed a degree of divorce because Y was pregnant, and not divorce, but for a degree of nullity. Degree of divorce and degree for nullity. The reason being the petitioner was pregnant from some other person. So the court will say that if you had earlier knowledge that Y had some relation with Z and still you proceeded further with the marriage, then you are supposed to take care of the child of Y because you are ignorant of the fact that the respondent is already pregnant. So you must have seen in the different movies that when there is one person X who married Y, who is already pregnant with some other person, and still their marriage has been considered to be a valid marriage, because any which ways that particular marriage is considered to be a valid marriage. So that is something which has consent of both X and Y. But why is it said that it cannot be considered to be a voidable marriage if X had the knowledge that Y is pregnant from some another person, or if he has sufficient doubts that Y might have been pregnant with some other person, and still he proceeded further with the marriage? Because once a person has the knowledge of the facts and then also they got married, then it is clear that they have given free consent. And once you have given free consent, that the marriage will be considered to be a valid marriage. So this is the main crux that you need to understand when you talk about marriages as such, that if you can see through it that the consent that was given by both the parties is free, then that marriage shall be considered to be a fully valid marriage. Only the three grounds when you talk about void marriage, even if the consent is given, the marriage will still be considered to be a void marriage because it is coming under void marriages. Because if you are not of legal age, if you are married in a Sapinder relationship, or you have already a spouse present, then the rights of the other party is going to be infringed. So that is something where which you will always be considered that the marriage is a void ab initio. The marriage never existed in the very first place. But when you talk about these type of conditions, where which you have by yourself, by a free consent, you have given that particular information. You have particularly consented to marry the person, and now after a certain period of time, you're coming back and saying that this is the condition because of which I don't want to continue. Then that particularly the court will say, okay, fine, but you were ignorant of the facts that during the marriage that particular person, the spouse is pregnant. And if you were not able to see that particular point and you were ignoring that point, then we cannot now, in the interest of Y, we cannot ask you to just let her leave in this particular situation and move forward. You knew that this fact, you should have considered it earlier, and then only you will be allowed. Then only this marriage would have been made a void marriage. But you consented and you move forward. So now it is your moral obligation and your duty to take care of Y as well as Z. So this is one reason. And the second reason is, if after the marriage, the person who is pregnant, if she is not allowed to continue with the marriage, then the child born, his validity will still be in question. So that is perhaps one another reason that if the petitioner is ignorant of the fact, then the marriage will not be considered as a voidable marriage, but rather a fully valid marriage, because they have given the consent. And if they are ignorant of the fact, that it is by itself assumed that the marriage is that they have the knowledge and they consented for that particular marriage. Okay, so now we have completed with our void and voidable marriage, a very important portion when you talk about Hindu marriages as such. And these are things that will be put up in front of you when you will be giving the paper of your CLAT examination. And the last concept and the last topic that has been left in regards to your Hindu Marriage Act is very important, is the conditions. Any marriage is solemnized whether before or after the commencement of this act may on the petition presented either by the husband, okay, or the wife. So either person can file a petition for divorce on the ground that other party first has, after the solemnization of marriage, had voluntarily sexual intercourse with any person other than his or her spouse. Has, after the solemnization of marriage, had voluntarily sexual intercourse with any person other than his or her spouse. Or has, after solemnization of the marriage, treated the petitioner with cruelty. Okay, so after the solemnization of the marriage, the person has been treated with the cruelty. These are the 2 points. This, please understand, this is given under the Hindu Marriage Act to both husband as well as wife. So there was a question that was put up in front of me when I was clearing the doubts of my students, that sir, in recent times we have seen that adultery has been removed and it's not been considered as a ground for divorce. So sir, now whether a person who have sexual intercourse with some other person will still be considered as a point of whether it will be still considered ground for divorce or not. So we need to understand here that it was something where which adultery has been decriminalized. So adultery was decriminalized, but it is still a ground of divorce. It is still a ground of divorce. You can claim a divorce if you come to the knowledge that your spouse had sexual intercourse, and that is voluntarily sexual intercourse with other person other than his or her wife. So this is adultery. This is adultery, but it is still a ground for divorce. Second thing is cruelty. So adultery is first. Second is cruelty. Cruelty can be of various types. It can be mental cruelty, physical cruelty, emotional cruelty. So you do not understand in detail what exactly is cruelty here, because once you will get the paper, you will be getting it marked that the person has been subjected to cruelty. So you can understand that yes, this is perhaps a ground of divorce. Has deserted the petitioner for a continuous period for not less than 2 years. So third one is desertion. Desertion for period not less than 2 years. Meaning which 2 years or more, if somebody has deserted somebody, then it can be a ground of divorce. Has ceased to be a Hindu. That is, fourth one is conversion. Okay. Has been incurably of unsound mind, or has been suffering continuously or intermittently from mental disorder. So this can be also a ground of divorce. Mental disorder, that the petitioner cannot reasonably be expected to live with the respondent. Okay. Now, mental disorder has been explained here. So this is something that you can study and you can understand that what exactly, what you can just pause the video and you can see to it that what exactly is mental disorder according to this, and what is psychopathic disorder. Both these conditions, if being fulfilled, then the person has the right to claim divorce. The fifth one is has been suffering from venereal disease in communicable form. So if you have any disease which can be communicated, then also this can be a ground of divorce. Now the sixth one is unsound mind. Mental disorder has been mentioned. Then the sixth ground is venereal disease. Venereal disease. The last seventh one has renounced the world by entering into religious, so renunciation of the world. So these are the grounds which are present both to husband and to wife also. Now there are certain grounds which are present, which are given only to the wives. So let's try to understand what are those grounds which are extra, which has been given to the wife also. This is one more ground: has not been heard alive for a period of 7 years. Yes, this is perhaps also important. The eighth one is renounce the world. Not heard for 7 years. So these grounds will provide a ground for divorce. If any of these grounds that are present, husband can claim divorce on the basis of these 7 grounds, along with wife also. Wife can also claim divorce. But there are certain grounds which are given only to wife. Wife may also present a petition for dissolution of marriage or the grounds in case of any marriage solemnized before the commencement of the husband and the wife. First is before the husband had married again before such commencement, or any other wife or husband married before such solemnization was alive at the time of marriage. So she already had another wife, provided the earlier wife has other wife is alive at the time of presentation of the petition. So if the wife is present before for example, in 1955, a person X already had a wife. So the legislation was created, the code was created in the year 1955. Now X again marries Z. At that point of time, if X already had Y was already living, then Z had the authority to claim divorce. Okay. And other ground is that the husband has, since solemnizing of the marriage, has been guilty of rape or sodomy. The second ground is if the husband has been subject to rape or sodomy, then the wife can claim divorce also. And then she has been married before she has attained the age of 18. So these are the two grounds which, if at all, yes. So these are the two grounds on which the wife alone can claim divorce from the husband if these two things are present. If the wife is present, or if she has been married before 18 years of age. So with this, we have completed divorce portion also. We have studied the important areas in regards to your Hindu Marriage Act, which is going to be helpful in regards to your preparation for your CLAT examination. With this, we come to the end of the Hindu marriage, which we have discussed what will be the conditions of Hindu marriage, what are the ceremonies that needs to be fulfilled. We discussed about the void and voidable and valid marriage. We discussed about all the sapindas that is going to be helpful for you. What exactly is Hindu, that also we have studied. We have studied the grounds of cruelty, we have studied the grounds of divorce, on which both the husband as well as the additional grounds on which the wife can claim divorce from the spouse or from the husband if any of the grounds which have just been studied has been present. And in this way, we have been able to understand that what exactly needs to be studied for your CLAT preparation. So after this end of the video, what I would request you is that you thoroughly understand this particular concept by reading it once more, by using the bare acts that will be present in online form, or you can use that. You can understand the concept along with this video. And once you have understood it, what you need to do is you need to start solving the previous year question papers, which is related to the Hindu marriage and divorce. and you see through it that what type of question has been put forward in your CLAT examinations. It is not like that we are not going to discuss the previous year question papers, and we'll obviously be studying the mock examinations also. We will try to analyze the question papers, and we'll try to understand how the concepts are being made applicable in the in the question papers. But as of now, once you have completed it, it is always advisable that once you have completed a concept, you need to revise it. And after you have revised it, you analyze it and you start applying it. So again, I would like to reiterate those three things, three P's, if you remember. 3 P's. What are those 3 P's? First is principle. First is principle, the principles that we are studying. Then it is persistence, and the third one is practice. So keep these three P's in mind and adhere to it, so that you can assure that you are able to apply these concepts and solve the questions that will be put up in front of you in your CLAT examination, so that you can score a good amount of marks in your at least in your legal reasoning portion of your CLAT examination. With this, I would like to thank you all for being present in this particular video. We will we will start with the Hindu Succession Act. We have studied the marriage. We have studied the divorce. Now we have to study the succession, how the succession take place once a person dies, how the property will be transferred to his wife, to his son, daughter, to his children, or to his mother, whether mother will be getting priority, whether wife will be getting, the widow will be getting priority, or how the property will be divided in regards to the Hindus. Then after understanding it, we will be able to get a clear idea that what succession means and how the inheritance takes place. Once we have completed that particular session, we will be moving forward with the Muslim marriages and how the succession under the Muslim take place, and how the marriages and the divorce takes place under the Muslim. So those concepts we will be studying in our upcoming videos. Till then, I would thank you all for being present in this video, and would request you to kindly adhere to these 3 principles, revise as much as you can, and try to solve questions as much as you can, so that once you go and sit in your examination of your CLAT examination, you are confident enough that the things that you have studied is in your head, and you are able to apply those concepts in your question paper. Thank you so much, guys, for being present in this video, in this lecture session, and we will continue on the Hindu Succession Act in our upcoming videos. Thank you, guys. Bye-bye. Take care.